bit about Matt real quick. He graduated with his master's in theology from Columbia Seminary and began his academic pursuits studying economics and political science, which led him to realize that a lot more, that the deeper questions were actually rooted in philosophy. And from there, he realized that all of the ought questions in which philosophy is rooted were actually rooted in theology. So, while he studies philosophy, theology, economics, and all those things, he really has a love for all of those subjects. So, tonight we're talking about the law above the law. You have a cool little insert here if you want to read more about it. And of course, please give all your attention now to Matt Marino.
All right. Well, thanks for having me again tonight. The topic is, as you have there, the law above the law. I'm not responsible for the proximity of my picture to Adolf Hitler's picture on that brochure. But hey, if it works, then whatever. So, the law above the law. In fact, I would say that a lot of what we're going to talk about tonight is a good way to avoid having pictures like Adolf Hitler's picture too close to your picture. You ever hear the expression, you can't legislate morality? Have you ever said that to somebody else? Well, it's one of the most widely accepted principles of nonsense on record. Now, if what you mean by that is you can't change the heart through law, that human legislation doesn't affect people's soul and stuff like that, then I absolutely agree. But as far as the words themselves go, it's a contradiction in terms, because the very definition of civil law is nothing other than legislated morality. How fast you drive on the highway is a moral issue. And there is no person on any side of the discussion that does not believe that it is not a moral issue, or does believe that it's not a moral issue. Well, let's show this by, first of all, traveling back in time to 1945, the International Military Tribunal at Nuremberg. It was at the end of World War II, and the full horrors of the Holocaust were beginning to come to light. And after the charter of the tribunal was drawn, the defendants naturally complained that they were being held to ex post facto laws, the legal version of that maxim that history is written by its winners. So in other words, they were saying to the prosecution, you're only trying us according to the laws of the Allied powers because you won. But in Germany, it was legal to do as we did. We were just following orders and all that stuff. And therefore, the whole trial is an arbitrary mockery of justice. Well, the chief counsel for the United States, Robert Jackson, needed a legal answer, and thus a law above the law. A standard which held above the victor and the vanquished alike. And so he cited what he called, quote, basic principles of jurisprudence, which are assumptions of civilization, all civilization. And so what we're going to see is three different things tonight that I want to draw your attention to. First of all, I want to make the case, by way of introduction, that everybody has a law above the law. This is not just something peculiar to theists or to Christian theists, but is something that every single person, even the person that thinks that they are trying to skirt around that issue, really does have a law that he puts above human legislation. Secondly, and thirdly, we're going to assess the secular version of that, the secular version of natural law, which I know a lot of secularists might think that that's a contradiction in terms. I don't believe in natural law anymore. Not that they ever did, but you might remember back in 1991, maybe some of you aren't old enough, but you remember when Clarence Thomas was being nominated to the Supreme Court. And of course, a lot of people, when they think back to that event, the thing that they remember was Anita Hill and that whole saga. But what people are usually slower to remember is that the main argument from the Senate committee was that Clarence Thomas actually had the nerve to believe in the archaic notion of natural law. That he actually believed that the Declaration of Independence and the principles that were spoken of there were actually foundational for all human legislation and for the U.S. Constitution. And so that was very troubling to a lot of people that still believed in the Declaration of Independence and the Constitution. But at any rate, we're going to see whether or not secularists have a natural law, and we'll see how it holds up. And then thirdly and finally, we're going to assess what I'm going to call the divine natural law. So this is kind of our big idea for the night, our main doctrine or our basic thesis. And if you want to argue against me, this will be the thing you're arguing against at the end of the day. Everybody's best argument for any civil law, so no matter who you are and no matter what law we're talking about, no matter how amoral you think that particular civil law is, everybody's best argument for any civil law rests on a law versus legislation distinction. And this law must be, in everybody's argument, an immutable, objective morality. And that's what I intend to show tonight. So first of all, let's look at that, by way of introduction, that first claim that everybody has a law above the law. This is very easy to show and absolutely impossible to refute. Simply answer this question however you like. Why should any particular civil law be what it is? Now, one person will say that such and such is the right policy because it promotes order or deters crime. Another will say that a particular law tends to the common good or maybe to the greatest good, or maybe to the greatest amount of good to the greatest number of people. And still others will appeal to tradition, or perhaps the obvious value of getting beyond tradition, or in other words, that the law is progressive. And other labels will be thrown around, such as patriotic, or practical, or realistic, or generous. And of course, everybody's going to think that his or her own political cause is going to be on the side of social justice, and all those slogans. Well, we might recognize every single one of these philosophies, and maybe you can name about a dozen more. But what we will not see, if we truly examine all of these answers, is the one thing that we've asked for. Namely, an ultimate answer to the ought question. None of these answers have really followed through with the ultimate reason as to why. Why ought a particular civil law be considered just to begin with? Now, the other thing to notice is really the flip side of the same coin. And that is that there is always a reason under the surface, way back on the assumption level, whether you've ever critically assessed it or not. And so, for example, if we press any of those answers a little bit further, for example, law and order. Law and order? Why should I care about law and order? And you're going to have to give me an answer that moves beyond law and order. Progress. Do you mean only what is most recent in time? But didn't Nazi Germany come after the Weimar Republic in time? And if you say, no, that's different. What makes it different? Something beyond one coming after the other. The greatest good. The greatest good is defined by who? The greatest number of people, or the greatest people in the number? The Nazis cornered the market on both of those too. And so on with all of the other answers. These answers all give to civil law what Euthyphro gave to Socrates in that very helpful dialogue of Plato on the subject of justice. So if I ask you right now, what is the essence of justice? And you reply, well, it's what I'm doing right now. Isn't that obvious? Or, it's what everybody recognizes to be good. You might have given me an instance of justice, or maybe not. But you've certainly not answered the question. And yet, deep down inside, everyone who has an opinion on these matters at all is absolutely convinced that the thing that they would like to see passed as law really is just. That it would always be just to do so under those circumstances. And that its justice should be obvious to everyone. To say it another way, everyone who believes that there is such a thing as the right kind of civil law believes so only, always, and completely on the grounds of some other reason, higher than the civil law. In fact, independent of any civil law that has ever been passed by human beings. And that's only another way of saying that everyone in the debate over civil law holds to some form of natural law. And I realize, especially if you study political science or political philosophy, that claim, that statement is going to seem absolutely outrageous to some here, or at least controversial. But here's what I mean. By natural law, I'm going to do the crazy, arbitrary thing here to define it by what the word actually means. By natural law, I simply mean that law which is in or equal to the nature of things. Hence the name natural. The law of nature, in other words. And there I don't mean the laws of science, but the way things are in the moral universe. In other words, it's the way it is, objectively, whether the officials of civil government reckoned with it or not. And this nature, this way things are, is a moral nature, a moral object of the mind. The only question remaining for debate once we start to see this will be whether that moral order can come out of nothing or whether it must come from some prior moral nature, or whether it may evolve from an amoral nature. And if it needs a cause, whether anything in the secular realm can qualify for that supreme moral nature, or whether we must go further back. And so that's really a simple way of introducing the first point, that everybody believes in some form of the way things ought to be. Otherwise, we wouldn't be here for a discussion like this. We certainly wouldn't vote in any election if we didn't believe that those things mattered, the way things are, or that this should be the way things ought to be. Well, let's look at the secular natural law. Now that we've seen what we mean by natural law, and we believe that each position believes that they're right, how does the secularist fare here? Now, already we have to define some more terms here. The word secular, might surprise you to know, is not a dirty word for people of faith. It comes from one of the Latin words for world, saeculum, which basically means this world with respect to this time and this place. And so, the here and now, so to speak. Secularism, anytime you take an ism and you put it at the end of a perfectly harmless word, that word now becomes the lens through which you see everything else. It becomes the central thing, the chief controlling factor to everything else you're thinking about. So ism, that's a worldview word. That means that whatever you're attaching it to is the thing that colors everything else. So secularism places that otherwise harmless word as the lens through which everything else is seen. Which, by the way, once you realize that's the here and now only, it's already a contradiction in terms that the most amateur philosopher can hopefully pick apart. Now, secularism denies the connection between transcendent morality and legal theory. In fact, it's the secularist that has taught us things like you can't legislate morality. We don't really examine the words that we're saying as they're coming out of our mouth. But it denies this connection between transcendent morality and legal theory because it reserves for public discussion the secular alone, the testable, the sensible, the common, and then by the card trick of calling some ultimate claims religious or mystical, and other ultimate claims public or empirical or simply rational. By doing that, we're really engaging in what Orwell called newspeak and marginalizing any ultimate claims that claim to be ultimate, openly and honestly, hoping that nobody will notice that all claims must ultimately rest on ultimate claims, whatever their source. So all legal theory rests on moral theory. That's just another way of saying what we've already said, that everybody believes in some form of natural law, the way things actually are, the way they ought to be. So all legal theory is a smaller circle within moral theory. Some legal theories attempt to deny this. Legal positivism and Marxism, both arising in the 19th century, dismiss the objectively moral dimension of law as a cultural power play. And yet both assert the right of another kind of power to determine the law. The difference between these two modern legal theories is that while Marxism, let's draw this chart up here, we're going to talk about this difference. You probably can't see those lines, they're a little bit dark, but I'll explain to you what I have in mind there. The difference between Marxism and positivism in this sense is that while Marxism deconstructs all civil law that runs against the revolutionary purposes of socialism, the positivist retains the right of law only by positing its moral character from the supposedly superior vantage point of each more evolved generation of wisdom. So the Marxist and the positivist are both saying that there is a right way or a right thing that ought to be in society. And yet in both we can see that we've not succeeded in escaping that need for a law above the law. Legislation does not make law, even in positivism and Marxism. And why is that? Well, let's just ask the Marxist and the positivist. What's wrong with the law that was law before you and all your more evolved and revolutionary friends showed up? What was wrong with that law? Answer, if you ask the positivist, well, things have progressed. Follow-up question, how do you know that what has come later, in this case, is better unless you have a standard that is above both yesterday's law and today's law? Now the Marxist is going to say, well, yesterday's law was the opiate to the masses, the false consciousness of the bourgeoisie. It was just there to keep them down. Follow-up question, but what's wrong with that? What if you and your friends had not passed this new law at gunpoint? Would the bourgeoisie law still be evil? There's no escaping a law above the law. But now we have to remember that there's a flip side to this coin. The secularist, who cannot avoid there being a law above the law at this foundation, still has to proceed in all of his political theory as if this is not the case. To avoid accountability to things bigger than civil law, he has to pretend that justice arises from human legislation. He must recognize a difference between law and legislation, but out of the other side of his brain, he must not admit that law stands above all human experience, judging all human experience. And so now we have to get practical and ask, can a secularist of any stripe hold to this distinction? Now I'm going to bring in some people that are a little bit closer to my political theory, and I'm going to say that they can't even answer this question. And so I'm going to talk about one guy that I really admire from the 20th century, Friedrich A. Hayek, part of the Austrian Economics School, who I'd recommend if you want to learn economics. You learn it from guys like Hayek and von Mises and Milton Friedman and so on. But he can't answer the question. Why is this right versus something else socially? Can any secularist really make a distinction between law and legislation? Well, he can try. Friedrich A. Hayek, what we would today call a libertarian, and another guy that I want to bring in, Francis Fukuyama, sort of a neoconservative globalist. These are two examples of thinkers who recognize that distinction and try to ground it in something closer to the ground than religion, or mysticism, I'm sure they would call it. For Hayek, the distinction was mostly critical, that distinction between law and legislation. Namely, here's what he's criticizing. He's criticizing what he calls the constructionist view of law in the modern West that elevated the rational innovator, the reformer of society, to the same place that was once occupied by Adam Smith's invisible hand, which Smith meant God, his providence directing economic activity just like he governs everything else. But Hayek was seeing that for this new theory, socialism was actually the new providence, the new intelligent designer in the civil sphere. And the consequences of this irrational view, according to Hayek, were things such as the French and Russian revolutions. And the basic reason for this failure could be found in the startling naivete of its fundamental premise, that one or a handful of enlightened bureaucrats in a distant capital could organize the entire social and economic life of millions of people better than those individuals themselves. But notice that what works, by contrast, in Hayek's mind, is a social order that arises from unintended, non-designed, evolutionary sources. The only things that are designed for Hayek are the proximate choices of individuals. And by the way, I agree with him that those proximate choices of individuals, the person that owns Walmart and runs those little scanners that go over the prices, in a much better place to look at the price system and arrange those according to those signals in some pointy-headed intellectual 3,000 miles away. I agree with Hayek about that. But if you leave it at that and say that this is what makes this right, you've not really answered the question. Now let me bring in this other guy. For Fukuyama, he says, quote, "The law is a body of abstract rules of justice that bind a community together, whereas legislation, on the other hand," he says, "corresponds to what is now called positive law and is a function of political power, that is, the ability of a king, baron, president, legislature, or warlord to make and enforce new rules based ultimately on some combination of power and authority." And so he at least understands that when we use phrases like the rule of law versus the rule of man, in other words, a law that stands over everybody, the electorate and Hitler, he understands that in this distinction, you have the thing that keeps people like Hitler in their cage, and yet he has no answer for it. What holds the law over the state officials in this thinking is the weight of the law's pre-existence. In other words, that it's always been there. And so in conservatism, mere conservatism, if you cut out its theological foundations, what makes a law so good is its precedent. He says the distinction between law and legislation now that we've been so enlightened, in other words, corresponds to the distinction between constitutional and ordinary law. Well, by that standard, the case for the American Revolution and independence would have been a tough sell. But this is just one more way of saying that might makes right, so long as you give might enough time to be normalized. Now, what I'm going to do here is probably going to disappoint a lot of people. Not only am I not going to tell you to vote for on Tuesday, because it's not a very exciting choice, write-in ballot. But not only that, but some of these isms, liberalism and conservatism, if you cut any of them off from their theological foundations, are nothing but secularism. Notice that both conservatism and liberalism, if left to themselves, have ultimately secular roots. Most conservative political theorists recognize jurists in the English tradition such as William Blackstone and Oliver Wendell Holmes to be pillars of conservative thought. And why? Because they root the ultimate justification for a statutory law in the common law. Because the common law represents the inherited moral wisdom of a whole people over the centuries. Now, the value of that, the value of conservative legal theory, is that its reliance on past precedent protects the people in any given generation against elitism, against demagoguery of a singular innovator or a gullible majority. But the trouble with mere conservatism is that what if you have barbarian morality in that particular people group all the way back? Where's the corrective? Now, most liberal political theorists counter the status quo by a kind of cosmic justice that confuses equality of outcomes and democracy of values with equality and liberty as such. A law that demands a justice at all costs, which is a contradiction in terms, because you have to take it from that guy over there to equal it out over here. Now, the value of modern liberal thought is that it insists on a constant corrective to the morality of a people. But the trouble with it is that it only does so by appealing to something that's never existed, namely to a future ideal state. And so consequently, what I would call mere conservatism and mere liberalism are both equally secular philosophies with no ultimate answer to the question, is your law above the law inherently just? The question is not, do you have a law above the law, but is that law above the law, that thing that makes it right for all people at all times, is it inherently just? Well, now that we've seen a little bit about why it doesn't work, let's look at divine natural law. One of the early Christian thinkers, Augustine, said that in temporal law, there is nothing just and lawful but what man has drawn from the eternal law. There's a long tradition in the Christian tradition, and ultimately from the Scriptures, that justifies the rule of law and goes a long way to explaining why those good things in Western civilization, for all that's bad in it, have happened. But nobody has better articulated the Christian position on the moral law than Thomas Aquinas in his 13th century masterpiece, the Summa Theologica. His definition of it may seem a little abstract at first glance, but here it is. He says that the natural law, as he defines it, is, quote, participation of the eternal law in the rational creature, an imprint on us of the divine light. Wow, that does seem pretty mystical. Bring that down to earth. Let me understand what you're talking about there. Because that might not seem entirely helpful unless you have a background with the theological usage of some of those terms. But another way to say this is that the natural law is our rational reflection on the eternal law of God. He's actually claiming that we can do that, not so much because of the power of reason, but because God has actually made himself known clearly in the creation. And one of the ways that he's done that is through when we study the laws of the nations. When we watch the Nuremberg trials, if we could, on C-SPAN and say, yeah, I think we can all agree that that's objectively wrong for all people and all times. And how do you explain that? What necessary conditions have to exist in the universe to explain the guilt of the Nazis in this case? This is an objective moral sense that he was arguing for, of right versus wrong, of good versus evil, of justice versus injustice in real, concrete circumstances that we all have access to. And deep down inside, we all know that what the Nazis did was wrong. I know you think I'm playing the Nazi card. It's an easy, eliminator. But there's a reason why it works. It does prove wrong, the idea. For anybody that has a soul, so let me challenge you. By the way, I've run into belligerent people all the time. They know where you're going. Fine, it's okay to throw babies up against the wall. Because they know where you're going. So I'm only appealing to you if you have a soul. If you don't have a conscience, if you're fooling yourself when you say, well, I believe that something is right, really? You just said by that example and by that belligerent response that you don't, because you see where I'm going. So you can't have it both ways. Well, what Aquinas was arguing for here is, first of all, something rational. He says the first hurdle to clear for a law is reason itself. Is it a rational thing? And so Aquinas wrote, law is a rule and measure of acts, whereby man is induced to act or is restrained from acting. For lex, or law, is derived from legare, to bind, because it binds someone to act. Now, the rule and measure of human acts is the reason. And so, law, in Thomas's theory here, which he's going to claim is the biblical theory, he's going to rest this on the Apostle Paul and a couple things he said at the beginning of his letter to the Romans. He says law has to be descriptive of a real, eternal standard of justice. It has to be normative. It actually has to be binding on people. And it has to be purposeful. There has to be a purposer, a legislator, to explain, to be a sufficient cause for all this legal motion. And now Thomas wants to show that human reason is actually an insufficient cause. Insufficient to produce this law in the first place. A finite reasoner, even a lot of finite reasoners together, or even the whole storehouse of reason, is not a sufficient cause, in other words, for just law to exist. If there's an objective end, an actual design, an actual greatest good of man, both for the individual and for the common good, then it follows that this end has an object which transcends either the individual or the community. The end has to be transcendent, or the cause would not be sufficient to move human beings to create law. Now, here's what Aquinas does. He sees a hierarchy where divine law is up at the top here, and it flows down to natural law, which was a concept that was already drawn out by pagan writers like Cicero and by Christian writers down through the centuries. But for St. Thomas in the 13th century, this natural law was a species, was a part of natural theology. In other words, one of the ways that God makes himself known in the created order. Or as Paul called it in Romans 1:20, the invisible things of God clearly perceived in the things that have been made ever since the creation of the world. And so what Thomas was claiming is no different than what Paul was claiming. That God has made himself so clear that the Nazis knew in their heart of hearts they deserved to die, Paul actually goes on to say at the end of chapter 1. That's a pretty strong claim. But Thomas sees something else from Paul in Romans, because he sees the civic law like a little circle inside of that big circle in Romans 1 of all the knowledge of God and creation. And so Paul goes on to say in chapter 2 that when the Gentiles who do not have the law, namely the law of Israel, by nature do what the law requires, they are a law to themselves, even though they do not have the law. They show that the work of the law is written on their hearts. In other words, deny it as much as you want, but if you were part of the Allied powers, and some of us still remember the people that defeated Hitler, maybe in our own family, they, according to Paul, had the law of God written on their hearts so clearly that they know they had to do something about this. And that brings it into sharp focus when it's such an extreme example like that. Now, if all this language seems archaic to us, it might be useful to know that Martin Luther King Jr., in his letter from a Birmingham jail, quoted Thomas Aquinas by name on this exact point. When he said, as Thomas said, a just law is a law that accords with the law of God Almighty. As Dr. King argued to those spineless, coward Christian ministers in the South that wanted to opt out of the civil rights movement. He cited this very reasoning in his appeal to modern-day civil rights. So legal reasoning is always inside of moral reasoning, which is always inside of metaphysical reasoning. That's why I did what I did in my journey in philosophy. This stuff is ultimately bigger than politics can answer. It's bigger than law can answer. It's bigger than economics can answer. It's ultimately bigger than philosophers can answer. These objects that ultimately justify, read Plato's dialogues if you don't want to read the Bible. It's interesting in and of itself. But this pagan is reaching around in the dark and realizing that nobody in his society has an answer to what is justice. Don't tell me what you're doing is just. That may be true, but that's not the essence of justice. Show me what it is. It's not the essence of truth, the essence of goodness and beauty and so on. Well, there's a second tier to the Christian idea of natural law. And that is, what is the actual object in the state that you can actually touch? Is there something of this divine law that actually is the focal point of civil government to begin with? And the Christian would say there is. The second tier of the Christian tradition on law is that this moral character of God is communicated most clearly in the image of God, in human beings themselves. Modern liberal political theory has gotten used to calling this divine image life, liberty, and property. And of course, Jefferson had to botch that up and say life, liberty, and the pursuit of happiness. That can mean whatever. My pursuit of happiness might be your end of liberty or something like that. But at any rate, it was life, liberty, and property in John Locke's writings. But the Scriptures had already mandated the same thing, mandating the state to defend this image, going back all the way to Genesis 9:6 and flowing forth into Romans 13, describing the sword that God delegates to the civil sphere. Now, one 19th century theorist, Frederic Bastiat, interestingly writing his little pamphlet the same year that Marx was writing the Communist Manifesto, Bastiat said it like this. He said, life, liberty, and property, this is man. And in spite of the cunning of artful political leaders, these three gifts from God precede all human legislation and are superior to it. Life, liberty, and property do not exist because men have made laws. On the contrary, it was the fact that life, liberty, and property existed beforehand that caused men to make laws in the first place. What then is law? Bastiat asked. It is the collective organization of the individual right to lawful defense. If every person has the right to defend, even by force, his person, his liberty, and his property, then it follows that a group of men have the right to organize and support a common force to protect these rights constantly. Thus, the principle of collective right its reason for existing, its lawfulness, is based on individual right. So what he's saying there is that a legitimate force against other images of God is only justified when life, liberty, and property has been attacked. In other words, when the image of God has been attacked. You want a verse in the Bible? Genesis 9:6. Oh, he's just talking to the ancient Jews. No, he wasn't. He was talking to everybody that got off of that boat with Noah, which according to the Bible is everybody. Because when he was starting over with the human race, he made a covenant to Noah, his sons, and all their generations. And so what he did is he said, I will require a reckoning. If anybody sheds the blood of man, by man shall his blood be shed. Now, leaving aside the issue of capital punishment and stuff like that and the form that takes, that's another issue. The state is instituted by God, Paul says in Romans 13, in order to execute God's justice against that attack against life, liberty, and property. The purpose of the state is not to produce happiness. It's to protect the life, liberty, and property of image bearers of God. Because if you attack that image, God was saying in Genesis 9, you attack God himself. He requires that reckoning. And so in the Christian position, God actually ordained the state. It's a good thing. It's something that says something about him. It gives him glory. It tells his story in a way that wouldn't be said if there wasn't somebody there with a sword protecting life, liberty, and property. And so in the Christian view, to say that there's a law above the law means that a law must reflect an unchanging justice if it is to be truly just. And therefore Thomas could go on to say that, quote, a tyrannical law, through not being according to reason, is not a law, absolutely speaking, but rather a perversion of the law. This is back in the 13th century. In the Christian tradition, you always had somebody arguing that the law stands above the king. The Magna Carta comes out of that atmosphere in 1215 from another Christian, Henry de Bracton, who was writing about the Constitution of the Laws of England, saying that the law stands above the king. And the Puritans, Samuel Rutherford, in his book in 1644, Lex Rex, the law is king. The Christian tradition from the beginning has always said that no man stands above the law. The law stands above all human legislatures, and only the Christian tradition gives you that answer. Others reach for it, others know you need it, but they have no ultimate basis for it. Now, this might seem all coherent as far as it goes, but you might say this, well, just showing that others have no answer for it doesn't mean you do. So sort of maybe what you're hearing is sort of a God of the gaps theory. It's very close to the same mistake people make about what intelligent design is saying. I can't explain it. There's a deficiency there. At least our view is coherent, but I have no evidence for it, and that's not what's being said at all. Things like the law of nations, when you study them, the Nuremberg trial, is that evidence? The protection of those who can't defend themselves, when we know in our conscience that that's actually wrong what Hitler did. That is the evidence. That is the truth that this is an image of God and that the purpose of the law is to protect that. Well, there's a couple of other objections before I go to questions. Maybe this will be helpful. Two other ones I can think of, besides maybe the God of the gaps misunderstanding. Just so I can head you off the past, and maybe you won't have these objections after I say them. Or maybe you will. It'll help you frame your objections better. But objection one is that the secular starting point's good enough. I mean, maybe you just don't even need an objective starting point. So I'm a secularist, I'm an atheist, I don't believe in objective morality, and that's fine. I was listening to a debate between Richard Dawkins and Alistair McGrath, and many other debates like it, and at the end of the day say, fine, it's not objective, it's not an objective morality, but we can do such and such. And list the way the history is going, or all these different evidences for it. And so it's good enough. One political science textbook says that a law, under this idea, is, quote, any rule of human conduct which is recognized as being obligatory. So you have a big enough majority. The obligation is strengthened as the majority is strengthened. But this will of the majority is the best we can do. And my reply to that is that it was a good enough majority that brought Hitler to power. And it was a good enough majority that preserved slavery in the South. And that is no argument that's going to marshal people to war to free slaves, knock down Berlin walls, and end communism and fascism. Only a law above the law can do that. Here's another objection. The secular starting point is preferable because it's the most conducive to liberty, since the claim to revelation involves information that only a privileged few claim to have. And so it's untestable, in addition to being inaccessible. Well, my basic reply to that is that you probably haven't listened carefully enough to what I said about what natural law means. The foundation of your view is also divine revelation. The law above the law is comprised of attributes of God that all people everywhere have access to, that all of our arguments depend on, but which we spend our lives denying or retranslating into other things. The concept, the idea of unchanging justice that all civil arguments depend upon show, prove, demonstrate that an invisible, eternal object of the mind is already the whole basis for even the secular argument, the whole basis for public discourse, so that even the most rabid secularism is always trans-secular. It's always depending upon arguments that depend upon the existence of God. Now, if I had another hour, I'd draw that out, but that's another subject. I hope we do that in the future on different arguments for the existence of God and atheism in general, stuff like that. But I'll leave it at that and open it up to questions, comments, or other misunderstandings.